Hi, I'm Tim Billick. I'm an intellectual property attorney, but I'm not your attorney.
Here's why the recent Supreme Court decision matters in the intellectual property space. We've been hearing a lot about what might happen to law in general, but let's do a deep dive on what might happen in the intellectual property space. Before we get there, what is the Chevron doctrine? The 438 federal agencies that we have, including the EPA, FAA, Department of Education, Library of Congress, and the USPTO, were all given deference to their statutory interpretations whenever there was some ambiguity. The Supreme Court ruled that, you know what, we don't really need to defer to federal agencies at all. So how does this apply to intellectual property law? Intellectual property law is governed in part by federal agencies. Any sort of rulings that the Copyright Office has been making on artificial intelligence, we no longer have to defer to them in the courts. This also applies to regulations under the Patent Act and the Federal Lanham Act. Courts just take it under advisement now. We're going to have just a whole mess of interpretations on statutes and regulations because we're not all looking at the same body of decisions from these agencies. So if I wasn't busy before, I'm certainly going to be busy now.